Good afternoon, everyone. Welcome to the Ramsey County Law Library Zoom CLE event for this month. My name is Shannon Stoneking, the Ramsey County Law Library Director. Our CLE presentation today is entitled, How the Flood Case Opened the Floodgates of Sports. And I am pleased that we have Marshall Tanick here to share his knowledge and expertise about this topic with us. We are also recording today's program as our first possible on-demand event. Today's live presentation has a CLE number assigned to it, which is 524888. Looking ahead to next month's CLE in April, the program will be Sarah McGillis from LCL on shielding the carer, understanding and managing secondary trauma in the legal profession, and that we have applied for the mental health credit. I do also want to offer a little disclaimer about the on-demand. Obviously, the live presentation, if you're here, you'll get the number, you'll get credit if you submit that to the CLE board. But for on-demand, we won't know. The process will require me to hold this event and then make sure after it that it was a successful recording, and then it could be viewed. So technically, we won't know until after the program is held whether it would be becoming available as an on-demand program. And that would be a separate number that would be assigned to it. So if you have friends out there that are interested, baseball, this one seems to be a high demand one. I've heard from a lot of people after we hold it, hey, is there a recording of that? Well, this year, hopefully there will be a recording of that. You can learn about any future CLE information that's posted on the Ramsey County Law Library website, as well as the Ramsey County Bar Association Barrister information website. You can also contact us directly at the Law Library if you have any additional questions or suggestions on future programs. Just a few housekeeping details for today. This event is a live presentation, and after I can view the recording, I will submit it to be available as an on-demand one. This will have a different number, as I mentioned, and today's is pending approval for standard credit, and I've mentioned that this event code number is 524888, and I will post that in the chat section after I introduce the speaker. Questions for the presenter are always appreciated. If you do have a question, please type that into the chat. And finally, a copy of the speaker's materials will be made available after the presentation today. Any questions about the process? And I don't see anybody with questions. So Marshall Tanick is a Twin Cities constitutional law attorney with the law firm Myers Noose Tanick Linder Robbins. He is a graduate of Stanford Law School and certified as a senior civil trial specialist. He writes and speaks frequently on a variety of legal topics, as well as the annual Supreme Court reviews and previews. And thank you for your attention. I will hand things over to Marshall.
Thank you very much. Thank you very much, Shannon. Could you put the cover page up there, please? There we go. Okay, thank you very much, Shannon. It's my pleasure to be here. I should have had a one credit for mental health CLE because we had a little bit of problems getting started here technically, and I'm still hearing an echo. So if I sound a little bit confused than usual, because I'm hearing my own self echoing. But it's a pleasure to be here again talking about baseball law. And while this presentation is going to talk about sports and baseball, it really has an underlying foundation of law. With the baseball season underway in the spring training.
Marshall?
Yes.
Can you see if you can turn off your other computer? I think that's why we're getting echo.
Okay, maybe that's it. Okay, is that better?
I think so.
Okay, hope so. Excuse us while we do some housekeeping. Is that better?
Keep talking. I don't know yet.
Better? Unfortunately, I can't close this. We're having technical issues. Hello?
Yeah,
Hello?
Marshall, just, I guess I'll tell you if you can turn off the other computer, that would be really helpful. If you can't.
Unfortunately, I'm not able to do that. My technical skills are lacking to do that. So.
Okay.
Is that better? No, I can't.
I think.
Can't do it. I got two computers going. I got one of them.
Okay, I think we're good now, Marshall. Just go ahead and start talking.
Hello?
Uh,
Hello? Hello?
Yep, we can hear you.
Is this better?
Yes.
Okay, I'm sorry. I told you we had some technical problems, but I think we've tried to clear them up, and I apologize for that. Anyway, to start over again, thank you very much for having me here, Shannon. It's a real pleasure to be with Shannon coordinating this program and heading it. As some of you may recall, Shannon's father, the late Dan Stoneking, was a great sports reporter himself, columnist. He covered baseball, although I think his greatest love was hockey, wasn't it, Shannon?
Um, I yeah, I mean, I guess so. I
All right. Well,
like
he was a great
sports.
baseball writer, and I used to follow him. And as a sports writer myself, I got into that business a little bit myself before becoming a lawyer. At any rate, today's program, as Shannon indicated, is called "Opening How the Flood Case Opened the Floodgates of Sports," and it's propitious at this time to talk about the flood case because it's an anniversary of sorts. Although this year is the 50. This week is the 53rd anniversary of the Supreme Court oral argument in the famous Curt Flood case, which did, in many respects, change the landscape of sports. And we're going to talk about the case today itself, but we're also going to talk about its implications and how it is spread, not just from the issue of free agency, which was the central issue in the Flood case, but to NIL, name, image, and likeness, and other contemporary aspects of the case. Much of the flood case and subsequent developments, including NIL, which we'll talk about in a few moments, stem from Minnesota. Minnesota has the roots of the flood case, and moreover, the roots of NIL, name, image, and likeness, stem from Minnesota, which seems to be a place where so much starts in the law these days. I am giving a similar presentation of this later this month in Florida to a different group, and I'm also going to tell them that much of this presentation stems from developments in Florida too. So Florida and Minnesota both kind of intersect here to deal with the issues that we're going to talk about. So let's get started here by looking at our table of contents first. And there's our table of contents. Moving right along, these are the things we're going to cover here, and then we'll move along here to the next slide. And we'll get started here. The reserve clause was the underlying issue in the Curt Flood case, argued 53 years ago this week, actually next week, March 20th, 1972, before the Supreme Court, and decided by the Supreme Court during its 1971-72 term in June of 1972. The reserve clause is really a series of provisions that have been in baseball contracts since the early days of professional baseball. Professional baseball started in 1869 with the Cincinnati Reds and grew, of course, slowly. But by the 1870s, many cities had major league teams, and there were leagues that were formed at that time. They weren't called the major leagues at that time, but they were professional baseball. Ball players did this for a living at least part of the year. In their ball players back in those days signed contracts with the teams. The contracts had the provisions that basically said, as cited here in the overhead in the PowerPoint, that a ball player is bound to stick with the team that has signed him, and the baseball player cannot participate in any, quote, negotiations or dealings with any other club. And he is the ball player who signs a contract, which all of them had to do, is, quote, bound, unquote, to play only for that team and cannot move to another team. That is the reserve clause. That developed back in the 1870s. So we're talking about a provision that's 150 years old as part of sports history, or at least it was 100 years old in the 1970s. It was 100 years old. Before it fell apart shortly shortly after the flood case. Similar clauses exist in other professional sports. In football, a similar provision, it was called the Rozelle Rule, which in professional football, the National Football League bound players to stay with their own team, and they couldn't move from team to team unless they were traded. Same thing in basketball and hockey as well. So the reserve clause was the provision in all sports contracts pioneered in baseball that prohibited players from leaving the team or playing for another team unless they were traded by the team. They could not negotiate or sell their wares or their skills to any other team except the team for which they signed a contract with. Not just during the season, but after the season too. They were, quote, bound, unquote, to that same team. Obviously, essentially, it's like a non-compete clause, and it had the significant effect, among other things, of not only reducing mobility, but keeping salaries low because ball players could not negotiate with any other team. They were stuck with the team that signed them, and they had to accept whatever salary that team paid them. Baseball players were notoriously low paid in those days. It was a low paying job, even for the star players through the 19th century and even into the 20th century, until Babe Ruth came on the scene and really helped create a more sizable market for some players, more sizable payroll for some players. Baseball players were low paid individuals. They were near the bottom generally of the professional salary range. Next slide, please. The reserve clause then existed for almost a century until it came under challenge in the 1970s. And that's the case we're going to talk about, the flood case. But we can't really understand the flood case unless we see its origins in Minnesota law. The Minnesota case that to some extent helped give rise to the flood case was a case called Eulander versus Hendrickson, which had nothing to do with reserve clause or free agency, but had a lot to do with setting the table for those concepts. In the Eulander case, the very young Nation Baseball Players Association, which was essentially a union of the Major League Baseball players. They started unionizing in the late 60s. It wasn't even called a union back then, but it was called an association. But they grouped together to do what unions do, which is to assert their rights in a collective way in various manners. The first major endeavor that the Baseball Players Association, or quote union, unquote, undertook was a case in Minnesota called Eulander versus Hendrickson. In that case, a game manufacturer, a board game manufacturer, this is before there were obviously video games, but one of those games where you spin a spinner, and it shows you what the ball player statistics are and and it uses their statistics to gauge how well the player does on this board game in using names and identities of players. And it was a fairly popular board game that used the Major League ball players' names and their statistics as part of the game. And you moved around the board like Monopoly based upon what you spun on the dial in terms of a baseball player's statistics. The union challenged that here in Minnesota. The named plaintiff was Ted Eulander. Why he was chosen, I don't know, but he was a Minnesota Twins ball player at the time, a fairly decent center fielder for the Twins. Good field, no hit, as the saying goes. But he was an excellent fielder, not a very good batter. But he played for the Twins for a number of years in the late 60s, and after that moved on to other teams. But Minnesota was selected as the venue for this case. It could have been brought just about any place because the board game was sold throughout the country. But the ball players, through their union, decided to bring the case in Minnesota, and Eulander was an activist in the Ball Player Association, so he lent his name to the case. Why was the case brought here in Minnesota? Well, there's a couple of reasons for that, but there are two main reasons. One is the lawyers who were representing the Ball Players Association at that time, or Ball Players Union, were here in Minnesota. So in Minneapolis, so it made some sense for to sue it out here rather than someplace else. Secondly, it was felt at the time that the Minnesota forum, a federal forum, would be congenial to the claims of the union because Minnesota at that time had a fairly pro-union bench. And the judges, there were only 4 of them at the time, the federal judges in Minnesota generally had a good record in union cases, at least from the players or ball players or employee standpoint. So those two reasons coalesced along with Eulander's volunteering to be the named plaintiff. The case was brought challenging the board manufacturers using their names and identities without compensating them. And the case was heard by Judge Philip Neville here in federal court in Minneapolis. And Judge Neville held that the players were entitled to be compensated for the use of their names and statistics and identities. Name, statistics, and identities. That was sort of the NSI back in those days. Now it's NIL. They were entitled to be compensated under what was known then as the common law, quote, right of publicity. And that was a property right that protects individuals, mainly celebrities, to get compensated for the use of their names or likeness. There had been other cases before. This wasn't the first case that recognized the right of publicity, but it made a big splash and got a lot of attention because it was a baseball case at the time when baseball was the most popular sport in the country. And it was a case that was watched all around the country, not just by lawyers and litigants, but by the business community as well. What evolved out of that case was the precedent that celebrities had entitled to be compensated for the unauthorized use of their names, images, and likeness, although the word images wasn't used back then, but for the use of their names and likeness. Another case here in Minnesota that grew out of that concept was a case that I represented the plaintiff, Spanky McFarland. Everybody knows Spanky from the famous Our Gang Little Rascals series. Spanky's name and identity and pictures in a large 30-foot mural drawing of him was used by a bar in the on the east side of St. Paul named Spanky's. And the owner of the bar had a big 30-foot mural of Spanky as he looked back in his movie days in the 1930s. And he had a menu that had Spanky burgers and alfalfa burgers and buckwheat burgers and all kinds of other Spanky associated terms. Spanky found out about this and decided to bring a suit to compel the bar to either compensate him or take his name off the bar. I represented Spanky in that case, and he prevailed in that case and ultimately received both the injunctive relief and some monetary compensation because of the misuse because he asserted his right of publicity, the same concept that came out of the Eulander case. And there were other cases developing along the same line. So the Eulander case is significant not only as an earmark for the right of publicity, but because it represented the first time that the baseball players union asserted rights on behalf of the players themselves and litigated those rights, which led to the next slide. And that's the flood case. To understand the flood case, one has to go back a century ago to the early years of the 20th century. In 1914, there was a breakaway league that was formed because the ball players were so underpaid at the time and subject to the reserve clause. A number of players, about a third of the major league players at the time, there were 16 teams back in those days, 8 teams in each league, about a third of the players bolted out of the major league structure and created their own league. Most of them were mediocre or lower level players, but there were some star players who joined this new rogue league called the Federal Baseball League. However, the existing major league clubs fought them in several ways. One way they fought them is they refused to allow those teams to play in their ballparks. Most of these ballparks were municipally owned. They were not owned by the teams back in the days, as mostly exist today. In those days, the cities owned the ballparks. They were recreational areas, but they would contract or lease them out to the teams to play during the season. The teams insisted that the cities not allow this new breakaway league to play in those ballparks. So the new league had a difficult time finding good places, good stadia to play in. There were some other restrictions that the existing Major League Baseball tried to impose on this breakaway league, and that ultimately led to the lawsuit that reached the Supreme Court in 1922 called Federal Baseball Club versus National League. The issue in that case was the new league, the league that was trying to combat the existing league, which lasted for a couple of years, by the way. It managed to struggle for a couple of years and ultimately went out of business because it couldn't find places to play. They sued the existing Major League Baseball under an antitrust theory, the Sherman Antitrust Act. And the claim by the emerging league was that Major League Baseball was engaged in an antitrust violation because they had agreed and combined and conspired together to prevent this new league from starting. That was the issue in the case, the Sherman Antitrust Act. The Supreme Court, in a unanimous decision, held that the antitrust law did not apply because baseball was not a business engaged in interstate commerce. Rather, the court said in a decision written by Justice Oliver Wendell Holmes, famous judge, Justice Holmes said that baseball is a sport, it's a recreation, it's not a business, and therefore, because it's not a business engaged in interstate commerce, it's not subject to any restrictions under the antitrust laws. And that was the holding in the Federal Baseball Club versus National League case. Baseball is not subject to antitrust laws because it's a sport, not a business. Decided by Oliver Wendell Holmes. Not to be confused, I might point out, with Oliver Wendell Douglas. Oliver Wendell Douglas was the name of a character of an attorney on the Green Acres program, Green Acres comedy program back in the 1960s. That some of you may remember, and some of you may have been seen in reruns and syndication. Oliver Wendell Douglas was the name was a parody of Oliver Wendell Holmes. Incidentally, Eddie Albert, who played Oliver Wendell Douglas in Green Acres, along with Ava Gabor, and some of you may remember the characters, Pat Buttram, Arnold the Pig, Fred Ziffel. Well, I'm showing my age here by talking about it. But at any rate, Eddie Albert, who played the role of Oliver Wendell Douglas in Green Acres, was from Minneapolis. So there's another Minneapolis connection for you. Next slide, please. Then we get to the flood case. 1922, Supreme Court says baseball is not subject to antitrust laws. Over the years, there were several other cases in which, but not many, but there were, I shouldn't say several, there were a few other cases in which baseball players sought to break away from their teams to play for other teams, but not for professional baseball in this country. Some of them went to Mexico, where they played ball in Mexico or in the Caribbean, because they actually got paid more to play in the Caribbean in Mexico than they did in the United States. But again, because of that reserve clause, they could not play for these other teams, and even in other countries. That was challenged on a few occasions by ball players in the 40s and 50s, but the Supreme Court adhered to its ruling in the federal baseball case and said, well, we've said that baseball is not subject to antitrust laws, so we're going to stick with that precedent, and threw out the few lawsuits that were brought by ball players in the 40s and 50s challenging the reserve clause. And then came Curt Flood. A little bit about Curt Flood. Curt Flood, as some of you baseball fans may remember, was a very good baseball player. He was not a superstar by any means, but he was a solid Tier 2 Major League Baseball player. He had a 15-year career. He started with Cincinnati, but the major part of his career was playing for the St. Louis Cardinals, and he had a final stint with the Washington Senators. Flood was a center fielder, a good fielder, oftentimes Golden Glove winner, and a good hitter too. He played 12 seasons with the Cardinals. He almost hit 300. He hit 85 home runs. He wasn't a big home run hitter. He was a leadoff man generally. He won 7 Golden Gloves, meaning top fielder of the year as a center fielder. That was Eulander's position too with the Twins, by the way. And he was an all-star 3 times. He played in an era in the National League where Hank Aaron, Willie Mays, and Roberto Clemente were almost always the all-star outfielders for the National League. And Flood was in the second tier of players, a good player, not a Hall of Fame caliber player, but a very solid player who was one of the anchors of some very good St. Louis Cardinal teams. His teams won 2 World Series in 1964 and 1967, and went again back to the World Series in 1968 when they lost in the 1968 World Series. Some of the players on those good St. Louis Cardinal teams included Ken Boyer, who was the most valuable player in 1964, Bob Gibson, great pitcher and Cy Young winner, Tim McCarver, later a baseball broadcaster, Lou Brock, who for many years held the record for stolen bases before it was broken by Rickey Henderson. So they had a very good, solid team and were one of the better major league teams when Flood was on them. But Flood's and Flood, as I said, was on two championship teams. The team lost in the 1968 World Series. Incidentally, some of you may recall, probably very few of you, in the seventh game of the 1968 World Series, the series was tied 3-3 with the Detroit Tigers. And the Tigers won the seventh game when Flood misplayed a fly ball in center field. He was an all-star and Golden Glove fielding winner, but he misplayed a fly ball late in the seventh game of the 1968 World Series that cost the Cardinals the game and the series. The Tigers won. That was the 1968 Tigers with Denny McLain, a 30-game winner that year, first 30-game winner and only 30-game winner since Dizzy Dean in 1934, who also played for the Cardinals. But moving on with Flood, after the 1969 season, Flood was traded to the Philadelphia Phillies. Fairly typical baseball trade. This was a player nearing the end of his career, and the Cardinals decided that they were going to go with a younger team, young youth movement, and Flood got traded. He was offered a $100,000 contract by the Phillies. That would have been one of the largest contracts of its time. The $100,000 barrier in baseball contracts came in the mid and late 60s. Mickey Mantle, I believe, received the first $100,000 contract in baseball near the end of his career in 66 or 67. Most of the very best ball players were making in the high five figures, $80,000, $90,000. Some got into the $100,000 range, but that was the tops for any player was making $100,000, maybe a little bit more. Those were the superstars. But the Phillies offered Flood a $100,000 contract. He turned that down. He would have been one of the highest players in baseball at the time. Not the highest, but pretty close to it. Flood turned that down. He did not want to play for the Phillies, who incidentally had very bad teams in those years. The Phillies were usually near the bottom of the league, except in 1964 when the Phillies almost won the pennant. The Phillies had a 7-game lead going to the last 13 games of the season, and they lost I think it was 9 in a row. And the Cardinals won that pennant in 1964 and won the World Series by beating the Phillies, and then the Phillies descended from there. The Phillies manager in that 1964 year, who blew it with losing it with a 7-game lead with 13 games left, the manager of the Phillies that year that lost out to Flood's Cardinals was none other than Gene Mauch, who later became the manager of the Minnesota Twins in the 1970s. But back to Flood. Flood refused to join the Phillies, and he said that he did not want to be. He said he felt he was being treated as a piece of property, and he equated himself as a slave. He said, "I'm being treated like a slave." He said, "Albeit a high-priced slave, but this is slavery. I can't decide where I want to play or work. I have to go where the team sends me to, and I can't negotiate with any other team because I can only negotiate with the Phillies, even though the Phillies offered him a good contract." So Flood sued Major League Baseball, challenging that 1870s reserve clause, and that was how the Flood case came to be. Flood was backed by and supported by the Major League Baseball union, the Players Union, which had gained strength because of the Minnesota Eulander case. Had they not won the Eulander case, they may not have felt that they had the strength and the power to go into federal court again, but because they won that Eulander case here in Minnesota, they geared up for this second case, a more important case, challenging the reserve clause. And obviously the implications from the ball player standpoint was immense. If Flood could break the reserve clause, then they would be able to negotiate salaries with other teams rather than being bound to whatever team owned them or traded them or wherever they were traded. So that was the genesis of the Flood case, as we'll see in the next slide. Flood was argued before Flood. The name of the case is Flood versus Kuhn. Kuhn was Bowie Kuhn, who was the commissioner of Major League Baseball at the time. Flood was the plaintiff, although he was, as I indicate, he was a named plaintiff, and he was the party was standing, but standing behind him was the entirety of Major League Baseball Players Association, who knew that a victory would allow them to negotiate with other teams and become free agents, a term that was not even in vogue in those days. A loss would mean the reserve clause would stay in effect as it had for nearly a century. Flood lost his case in the trial court in the New York federal court in New York, and he lost before the Second Circuit. The Second Circuit, both courts cited the Federal baseball case, and said because that was precedent, a Supreme Court precedent, he could not sue under federal baseball because Flood's lawsuit was predicated as an antitrust case. Flood alleged that the reserve clause constituted a restraint on trade violation of Section 1 of the Sherman Act, 15 U.S.C. Section 1, which prohibits conspiracies, combinations, and restraints of trade. Because Flood alleged that all of Major League Baseball, all the teams, agreed to have the same contract, the reserve clause, that constituted a violation of the antitrust clause. So he sued on the same basis as the federal baseball case did. The federal baseball case dealt with different issues, but in both cases, the underlying issue was, does a combination or conspiracy among baseball teams to restrain trade violate the Sherman Act? In the federal baseball case, the Supreme Court said baseball is not subject to the antitrust laws because it's a sport, not a business. So here we are in 1972 revisiting that case. So Flood was represented in the Supreme Court. The ball players lost the case both in the trial court and the appellate court, and then they appealed to the Supreme Court, and the Supreme Court took the case, which surprised some people because the case, there was a precedent from 1922, and in a couple of other cases, they indicate a few of the cases, the court would follow that precedent. So many observers at the time felt that the court would deny certiorari because it was a settled issue. But the court did take the case, and Flood was represented in the Supreme Court by Arthur Goldberg. Arthur Goldberg was a former justice of the Supreme Court. He had been appointed to the Supreme Court. He was a liberal Democrat. He had been appointed to the Supreme Court in the early 1960s by John F. Kennedy. So Goldberg had served on the court for about 5 years before he left the court, and ultimately he returned to private practice. And here he was back before the Supreme Court, before basically the same judges, his colleagues on the Supreme Court, arguing for Flood. It's extremely rare for a Supreme Court justice to argue a case in the Supreme Court. One reason is because they don't go back into practice after they're done. Usually they complete their term, they usually serve on the Supreme Court until they either retire and then sort of hang around on the peripheries of the federal court system, or they die. But Goldberg was still young enough that he went back into private practice. He was a labor lawyer, an employment lawyer in New York City, and a highly regarded one. And he was selected to represent Flood. And he argued the case in the Supreme Court. His performance, as indicated in this slide, was widely panned. And he was criticized by those who observed his performance. They said he did not do a good job. He wasn't well prepared to take on some of the questions his former colleagues asked him, and he was generally criticized. But probably the main reason he was criticized is he lost. The court ruled 5-3 against Flood. The decision was 5-3. Flood lost his antitrust claim in Flood versus Kuhn. The decision was written by Justice Harry Blackmun from Minnesota. Minnesota's Justice Harry Blackmun, who wrote the decision. The other Minnesota justice on the court, Chief Justice Berger, concurred in that decision. It was a 5-3 vote. Blackmun had been on the court for only a couple of years. He had been appointed by Richard Nixon after Nixon's two nominees, Clement Haynsworth and Robert Carswell, both Southerners, were defeated and were denied, were voted down in Congress and in the Senate, rather. So Nixon had tried to appoint two Southern justices to the court, Clement Haynsworth of South Carolina, Carswell from Florida. They were both rejected by the Democratic-controlled Senate in those days. So Nixon then went to Warren Burger, and he said, who do you think I ought to appoint here? I'm having trouble getting the kind of people I want. I want a real conservative judge. And Burger recommended his boyhood chum from St. Paul, Harry Blackmun. And he told Nixon, if you want a real solid conservative that you can rely on and count on, Harry Blackmun's the man. And Harry Blackmun was elevated then from the Eighth Circuit, where he had been serving, to the Supreme Court. He wrote the Flood versus Kuhn decision, 1 year before Justice Blackmun wrote Roe versus Wade. Next slide, please. In the Flood versus Kuhn case, Blackmun, in a portion of the case, in a highly unusual portion of the case, he listed 187 names of iconic baseball players. One segment of the opinion just lists 187 names of baseball players, famous ones, well-known ones generally, at least well-known to the baseball community, going way back to the 1870s. Of course, he listed Babe Ruth and Ty Cobb and Tris Speaker and Walter Johnson and Honus Wagner and all the big stars of the day, and lesser ones too. And he filled up 3 pages of the court's decision with the names of baseball players, solely just listing them. And it certainly showed that he was a baseball fan himself. Incidentally, one of the current Supreme Court justices is a huge baseball fan, Brett Kavanaugh. As you may recall, during his confirmation hearing, Brett Kavanaugh, an issue arose that he had he had a $20,000 outstanding loan that he had taken, and he was questioned about that. And it turned out that he took a $20,000 loan to buy tickets, season tickets, and a private box to the Washington Senators games in D.C. because he was a huge baseball fan. Well, Blackmun was too, as indicated by his being able to tick off 187 baseball names. And if you read that decision, you can appreciate that he had a great love for the game of baseball. Incidentally, well, he named just about every famous baseball player of the last century, all the big names. He missed one name, Mel Ott. Mel Ott was a slugging right fielder for the New York Giants and a very good baseball player. He's in the Hall of Fame, and he also was a manager of the Giants. He was about the only really significant baseball player that was left out. Ott was no longer living at the time, but when Ott's son contacted Blackmun afterwards and said, "Gee, Mr. Justice Blackmun, you left out my father. He was a Hall of Fame baseball player for the New York Giants." And Blackmun wrote him an apology letter and said, "Yes, if I had to do it again, I would have included him in my decision." But anyway, that was just a listing of the baseball players. The case went on. Blackmun then said that the federal baseball precedent was an exception and an anomaly. He said that the federal baseball case was not well decided, but he said Congress was aware of that decision and didn't do anything about it for over 50 years. And he said, if the Congress wanted to change the law and enact the law that barring the reserve clause, Congress could have done it, but they didn't take any action. So apparently Congress acquiesced in our 1922 decision. Then he went into a discussion of precedent. And the issue of stare decisis was significantly discussed by Blackmun in that case. And the issue, Blackmun acknowledged that the federal baseball case was not a wise or sagacious decision. Saying that baseball is not a business, Blackmun said, is wrong. And certainly in today's environment in the 1970s, it's an anomaly to say baseball is not covered by the antitrust law. However, Blackmun said we rely upon precedent and stare decisis. And he had a section of the decision that talked about the importance of sticking with precedent or stare decisis, even if he thought that the underlying precedent was wrong. He said stability and certainty and all the reasons that support following precedent require us, he said, to uphold this federal baseball decision, even though we think it was a bad decision. That apparently was that observation apparently has been lost on the current court, some would say, who find that precedent doesn't mean too much if they want to reverse precedent. But Blackmun stuck to precedent even though he said the decision was wrong. And one can think about that in the context of the Dobbs case, Dobbs versus Jackson Women's Health Organization, the decision that overruled Blackmun's ruling in Roe versus Wade, when Justice Alito took on the Roe versus Wade decision and said it's precedent, but we think it's wrong, and therefore we're going to reverse it. And there have been some other cases we all know, which the Supreme Court has done likewise. But in the Flood case, Blackmun stuck to precedent, even though he did not like that precedent. And he said, if there's any changes here, it's a matter of legislation. We're not going to change our precedent. There was a dissenting decision, that is not dissecting, a dissenting decision. Justices Douglas and Brennan said that the federal baseball case of 1922 was a, quote, derelict and should be overruled. And Justice Thurgood Marshall weighed in as a dissenter, saying that the reserve clause that prevented Flood from negotiating salary constituted a form of, quote, involuntary servitude under the 13th Amendment, sort of emulating Flood's remark about being a high-priced slave. But that was what happened in the Flood versus Kuhn case. It was argued on March 20th, 1972, 53 years ago next week. It was decided by the court, as it usually does in its high-profile cases, in the last week of that term in June. Next slide, please. Flood opened the floodgates. Even though Flood lost his claim and the reserve clause stayed intact, it didn't stay intact very long. There was a pair of arbitrations. Remember that by this time the union now had been certified, and the union was able to. The baseball players union went through 2 arbitration proceedings in the mid 1970s. One was a case involving Catfish Hunter, the Oakland A's pitcher, and another was Andy Messersmith, the Los Angeles Angels player, now called the California Angels. In both of them, in both cases, the arbitrators ruled in favor of the ball players. Hunter's case was a little bit different because in Hunter's case, the owner at the time, Charles Finley of the A's, didn't pay him what he was entitled to be paid under his contract. So he sued. It was barely a breach of contract claim. But the Messersmith case was a pitcher. He was a 20-game winner, Andy Messersmith. He was a 20-game winner for the Los Angeles Angels, now known as California Angels. He refused to be traded. And he refused to go along with the trade, and he then sort of did what Flood did and challenged the reserve clause, but it was an arbitration, and an arbitrator ruled in his favor. Arbitrators are less bound by precedent than courts are, and an arbitrator found that the reserve clause was unfair and a violation of the Antitrust Act, even though the Supreme Court had said the opposite. And an arbitrator ruled that the reserve clause could not be enforced against this ball player, and that was an arbitration ruling that led to free agency. As a result of those 2 arbitration rulings, after the Flood case, the floodgates were open because the ball players union then negotiated a system that's still in effect after 50 years for salary arbitration. There have been some tweaks to it, but basically, baseball players now are bound to their teams for 5 years. They're bound for the first 5 years of their career, and after 5 years, they can challenge they can negotiate in negotiating a new salary for going forward. If they don't reach an agreement with the team, they can go to arbitration. Both the team and the ball player submits a high-low. The ball player submits what he thinks is fair. The team submits what they think is fair. And it's a high-low. It's not the arbitrator either picks the ball player's figure or the team's figure. That tends to make both sides a little bit more reasonable because there's no middle ground. And arbitration is now enforced for ball players after they reach 5 years, and it's had the effect of tremendously increasing baseball salaries, as you can see in this slide. In the 1970s, the Flood era, the highest paid baseball player was making about $560,000. That was Mike Schmidt, all-star, most valuable player, a slugging third baseman for the Philadelphia Phillies. That was Flood's. Would have been Flood's team. He was the highest paid player, and the top stars of the day were making $200,000 or $300,000. Schmidt maybe getting close to $500,000. That was the 1970s. That was after the Flood case. Today, we all know what's happened to salaries. Otani, the pitcher hitter for the Los Angeles Dodgers, Japanese player, gets $70 million a year. Aaron Judge, the slugging most valuable player for the Yankees, he's at $40 million, and so on and so forth. 15 teams have at least 15 teams, 15 of the 32 Major League Baseball teams, 15 of them have players with at least one $25 million salary, and many have many more. Many have many more. The average salary at the time of Curt Flood, and Flood, remember, was a star player, not a superstar, but Flood was a tier 2 player. But the average salary, the Eulanders of the world back then, were making $20,000 or $30,000. That was the average salary for most ball players on major league salaries. The minimum was $8,000. Rookies were making $8,000. Decent ball players have been around for a few years, $20,000 to $30,000. good ball players 40 to 50, and superstars. The top players were making in the high five figures, low six figures. Today, 25 million per player. The average salary for a Major League Baseball player today, which was about $20,000 or $30,000 in the flood era, is about $8 million for the average. And most are making significantly more than the average because there's a lot of younger players or rookies or newer players who are making only 2 or 3 million. But the average is 8 million per player today. The floodgates continue to open even after Flood lost his case. In 1973, the football players brought a lawsuit in Minnesota called Mackey versus NFL. That was named after John Mackey, the star tight end for the then Baltimore Colts. He was a very good player for the Colts, tight end. In fact, the college tight end of the year award is called the Mackey Award. The best college tight end wins the Mackey Award. Mackey was a star player. The Football Players Association was just forming at that time too. They brought a similar flood type case against the Rozelle Rule. The Rozelle Rule was football's version of the reserve clause, which barred players from moving from team to team unless they were traded. Barred any negotiations with anybody but their own team. Mackey challenged that in Minnesota, Minneapolis. The same lawyers, not the same lawyers, but the same law firm was involved. Because they had success in the Eulander case, the case was brought in Minnesota before Judge Earl Larson. And Judge Larson ruled that the Rozelle Rule, the restriction on player movement in football, constituted a violation of the Antitrust Act, contrary to the flood case in 1973. Judge Larson's decision, Earl Larson's decision here in Minneapolis, was affirmed by the Eighth Circuit a few years later. So as of the mid-1970s, the reserve clause in baseball had been eradicated because of the post-flood arbitration and led to the salary increases, and likewise in football as a result of the Mackey case. And Judge Larson's work in the Mackey case, which the Eighth Circuit affirmed, was a stellar work done. The decision was a stellar decision written by the judge, aided by his outstanding law clerk who did most of the research for that decision and who is now presenting this CLE. The similar restrictive provisions also fell in football and basketball, hockey, and other sports. And now the type of restrictions that were imposed on players back in the flood era no longer exist in any professional sports. They all have different machinations, but generally players are allowed with some restrictions to negotiate with other teams. In football, as we know, the teams can keep certain players by giving them what's called a franchise tag, as was discussed about with Sam Darnold recently. They can keep 1 or 2 players, and they sign players to long-term contracts. So the star players in football now get long-term contracts, and players move around. And we've just seen right now, in the last week or so, how the players in football are moving around from team to team and are able to negotiate large salaries unless they're subject to long-term contracts. All of that is the product of the flood case, even though Flood lost the case. Next slide, please. And then NIL. That's the hot topic these days for amateur sports, so-called amateur sports. I guess they're not amateurs anymore. NIL means name, image, and likeness. It's applicable to college athletes and even high school athletes. Yes, we're seeing some high school athletes sign contracts to use their name, image, and likeness. Where did that come from? Well, again, it's traceable in some respects to the Eulander case here in Minnesota. The case that established NIL was called NCAA, National Collegiate Athletic Association. That's the organization that regulates college athletics, versus Alston. That's not, for you baseball fans, that's not Walter Alston, the former manager of the Brooklyn and Los Angeles Dodgers. This is a different Alston. This is a UCLA basketball player whose name was Alston. The case had been in the California court system for about almost a decade. It goes back to 2013. 8 years of litigation below, and finally reaches the Supreme Court. The issue in that case was the NCAA, the national organization that regulates college athletics, which all the colleges belong to. University of Minnesota and every other college belongs to it. restricted college players, college athletes, all college sports, but it impacted mostly the high revenue sports, football, basketball, hockey, some places baseball in the South. But it basically said that players could not receive any outside compensation. They could receive tuition and room and board from the schools, and they could get small stipends. They could be given summer jobs, but they could not get any compensation from either the schools or outside the schools, from commercial entities that wanted to sponsor them. And that's a long-standing rule that has been enforced in college athletics for many, many years. Now, there were ways to try to get around that, but they weren't legal. Money under the table and other provisions, furnishing vehicles, paying family members, hiring family members. There were ways that the big-time college athletic teams tried to get around this, but essentially players were restricted by NCAA rules from receiving any outside compensation, but not after the Alston case. The Alston case was a unanimous decision, and it was, again, an antitrust case. The college players claimed that the restriction on receiving outside compensation constituted a violation, a restraint of trade in violation of the Sherman Antitrust Act, the same law that was raised in the federal baseball case and rejected, the same law that was raised in the federal baseball in the flood case and rejected, now came back again to the court in the NIL college case. And the issue was, does the restriction, when all the colleges join together and their association bars players from receiving outside compensation, is that a violation of the antitrust laws? And this time the court unanimously said yes. The majority opinion was written by Justice Gorsuch, and he said that the restriction is invalid, and he said that that student athletes should be given a measure of compensation consistent with the value they bring to their schools. And therefore, the schools cannot restrict outside compensation. A concurring decision by Justice Brett Kavanaugh was really the attention grabber. His decision concurred with the majority, but he made the comment that nowhere else in America can businesses get away with not paying their workers a fair market rate. That was the signature remark of the concurring decision, but that's also the theme of the majority decision. That since businesses can't conspire, businesses can't agree what their workers will be paid, colleges shouldn't be able to do the same thing either. Now, it's kind of a Marxian philosophy, and you rarely hear the Supreme Court, especially the current composition of the Supreme Court, lamenting how employees were not being paid their, quote, fair market rate. It's a phrase that rarely is heard from the Supreme Court, like never, at least the current composition. But in this case, they said college players should be entitled to receive a fair market value of their services. Interestingly, as you see from the italics there, the decision, the Kavanaugh concurrence, but the main decision as well, viewed the players as workers, employees. That was the premise of the NIL ruling, that the college athletes, football, basketball, other sports, work for the university. Well, the players then said, if we work for the university, maybe we can organize and have a union. The NLRB and the Biden administration agreed and started certifying college athletic unions. That decision was reversed, was later, well, it's been reversed, but it's no longer, it's not being enforced, I should say, because the Trump administration has disabled the NLRB from even proceeding. But there was a decision in the Biden NLRB that college players are entitled to form unions. However, the desire to form unions has been vitiated by the large amounts of money that the players can receive through NIL. And we've seen it, as I said, at high school levels too. And we're all familiar with what's been going on. It generally, in the upper level colleges, the Division I major colleges, the NIL the name, image, and likeness payments. The going market rate the minimum going market rate to be competitive for a top-notch quarterback is $1 million. In some of the big-time schools, the big-time schools, the Alabamas, the Texases, and Ohio State, it's $1 million plus. The Ohio State football team that won the national championship this year had an NIL payroll of $20 million. We'll come back to that figure in a minute. $20 million was what Ohio State players received through these NIL payments. Technically, the NIL payments come from outside the university. The university gathers sponsors to put into a fund, and they pay the players. And it's prevalent, of course, in big-time football and basketball, to a lesser extent in hockey, especially around Minnesota, in the northern states where hockey is a revenue-raising sport. Women's basketball a little bit, women's volleyball a bit, but the minor sports, the non-revenue-raising sports, are bypassed pretty much by NIL. But there's a new factor that's in play too now, and that was a class action called House versus NCAA. And in that case, a $2.78 billion fund was set aside to pay players, college players, in lieu of or in addition to NIL. This doesn't override NIL, but now each college is given a fund to pay players. In Minnesota, there's a $21 million fund that will be available for the university to pay players from their own funds, not from NIL funds, but the NIL funds will be added on top of that. So the idea was to prevent, to at least limit some of the NIL funding by letting colleges pay the money themselves rather than from outside entities. But as it's worked out, both systems are going to exist. The colleges will have about $20 million each to pay players, and the players can also raise money from outside sources, commercial sources, using their name, image, and likeness as a result of the Alston case. Next slide, please. Next slide. And there we are. So that's how we've got here. And I have a little test here at the end, but I don't think we have time for the test. Well, we have 1 minute here for the test. But I think what I tried to show here is how the Flood case really is a derivative of the Minnesota Eulander case, then the Flood case. And even though Flood and the Union lost the case, they came out the big winners, big time, by ultimately doing away with the reserve clause, the Rozelle rule, allowing free agency, and resulting in these soaring salaries. And because these salaries were soaring so much, and because of the concept of players banding together, that led to the Alston case, and that resulted in the NIL, name, image, and likeness concept that has significantly changed the landscape of college sports in many ways. I think we have 1 minute for the quick quiz. You can take it yourself, but I'll give you a quick quiz here before Shannon pulls the plug here. Well, you can take it later. You can look at it later because there may be a few questions and comments. So if anybody has any questions, comments, concerns, or criticisms, keep the criticisms to a slight degree, please. I'll be happy to answer a question or two if we have time while you're taking the test.
All right. Well, thank you so much, Marshall. Appreciate your comments and expertise today about all of these background issues with baseball and kind of how it's sort of guided us towards all these things in reference to sports. I do not see any questions at this time. So, any comments? We have a loved this presentation. All right, thank you. For those of you who
wait, excuse me, Shannon, do we have time for the quick quiz? If I can do it in 1 minute,
sure,
quiz?
Sure, we could do that.
All right. After his baseball career ended, Curt Flood became which of the above? Baseball color commentator, artistic painter, lounge singer, minor league baseball coach. I'll have to answer them quickly for you, but you get 5 seconds to answer the question, okay? I know the answers. The answer is B. He became a painter.
Wow.
Artist. Number 2, who defeated the Cardinals in that 1968 World Series? I think I gave that away already. I think I said that was the Detroit Tigers for you Detroit Tiger fans. Denny McLain, 30-game winner. Mickey Lolich won 3 games in the World Series. Flood missed the fly ball in the 7th game. Bowie Kuhn was succeeded as baseball commissioner by whom? There's a typo there, fans. That should be Bud Selig, Brewers owner Bud Selig, Yale president Bart Giamatti, Olympic organizer. Okay. The answer is C, Peter Uberoth. Remember him? He was the organizer of the 1984 Olympics, and he became the next commissioner of baseball. Next slide, please. We got a couple more quick questions here.
Here we go.
Before the Supreme Court, Harry Blackmun represented whom? Blackmun was a Twin Cities lawyer before he went to the Eighth Circuit. Which one of these big entities did he represent? Big client of his at the Dorsey Law Firm, by the way. Dorsey Law Firm. It was the Mayo Clinic. A. Flood's lawyer, Arthur Goldberg, left the Supreme Court. Remember I said he was on the Supreme Court? He left it to become what? He became the United Nations ambassador. Lyndon Johnson leaned on Goldberg to become UN ambassador to deal with the main issue at that time was the Vietnam War. And Johnson asked Goldberg if he would step down from the Supreme Court to become UN ambassador, largely to deal with Vietnam War issues. Goldberg did it for a couple of years, then he went into private practice, and then he became Flood's lawyer. And the NIL cases was named after, okay, I gave that one away already. The NIL case, Alston versus NCAA, that was named after a college basketball player. And do we have any more? Is that 6? What do we have next? I think we're done. So there's your 6 questions.
All
right. Another
right.
question? No, that's it. So one more slide?
Yep, nope, that's it. That's the final slide.
Oh, I thought I was going to do 9 questions for 9 innings in baseball, but I guess the last 3 dropped out. Well, we're out of time anyway. I hope you enjoyed this presentation. Obviously, I enjoyed giving it. And Shannon asked me from time to time to give various presentations. I'm happy to do, and some of them deal with sports issues. And I hope you enjoyed this because this isn't only about sports. This is about law and sports and other facets. And I try to bring them together. The intersection of law and baseball, I think, provides a lot of interesting and entertaining divertissements, especially now that the baseball season is about to begin. Go Twins.
All right. Well, thanks again, Marshall, and thanks again, all of you attendees. I will send out Marshall's PowerPoint later today, and we'll see you in the future for additional CLEs. Thanks so much.
Thank you.
Here.